So tell us, share with us, what's the general process like, for a divorce in California?
Sure. So one party files for divorce. It makes no difference who that is. It's not a race. It's not a fault state. We'll get into that some other time.
I've heard, in the past, I don't know if this is another myth or what, some people tell me if you file first, you're in the upper hand and you have more advantage. I don't know if it's true or not.
It's not true at all.
Okay.
I will say the only difference is if we are going to trial, the petitioner will put on her or his case first. You don't want to go to trial, so hopefully that'll never happen. But one party files the requisite documents. And as I said before, no offense to the judiciary or to my colleagues, take a deep breath. It's like filling out some documents for the DMV. And so it's a handful of documents, can be done in less than a half an hour. Then you serve the other side. Now, in my practice, 90% of the time, I don't serve the other side because that is not treating them with dignity and respect that hopefully they do deserve. So what we do is we tend to send it to them via email, or we call them up and let them know that we're not going to send a process server unless it does require it. And there's cases that it does require. After that part, then they have 30 days to respond with their response. Again, a very perfunctory document that they can provide. I'm less concerned about the response and more concerned about how they are treating each other and the children during this process than what's going to be on those several pages of documents. They are human beings going through a life transition. So it's far more important to me as to what's on that paper, not what's on that paper, but what's going on in their lives.
Right.
After the petition and the response has been filed, we're in what I call like the 4D stage, due diligence, discovery, and disclosures. So what do I mean by that? Well, as one's counsel, our role is to educate, advocate, and act in our client's best interests. Educate, advocate, and act in our client's best interests. We do that based upon the law, our legal experience, expertise, common sense is a big one, as applied to the facts. Well, we don't know what the facts are, and often our clients may not know what the facts are. So we're in this stage where the parties have fiduciary duties of disclosure. So if you ever bought a house, remember that loan application you had to put together and how it was a pain? Guess what? You get to do that again through the divorce. It's more than that,
the concept is that.
The concept is that. And then you exchange information regarding those 5 fundamental areas that I was talking about: domestic violence, custody and timeshare of children, asset and debt division, support, and whatnot. We'll hopefully exchange settlement offers. We address emergency issues.
Right.
Then we settle the entire case, and with dignity and respect for both sides. If we need to go to court, sure, we can go to court, but it's my preference that we don't go to court. I've made a reputation of going to court. I don't necessarily want that, but it is what I do, and it's a skill set I have. And perhaps having that skill set allows me to settle the majority of my cases. We settle the case. We have the divorce decree on top, which allows the parties so the parties can be divorced. And then there's about 12 to 15 pages that's all their rights and responsibilities, again, in those 5 main areas. We submit it with the court, and they're divorced.
Oh, okay, great. So move on.
Yes, move on. Eat, drink, and remarry.
Remarry. Okay, great.